Smash. I'm from the events team in the Leeds Extended Reality Society, and thanks to our friends in Marks and Clerk, Graham Murray, Simon Portman, and Andrew Hartley, and Liz Roberts, which I think is still listening. They offered to present us this webinar on the pointers and pitfalls for immersive tech startups. And I have to thank you because I don't know if you're aware of this, but it's a first event, the first official event that this society is bringing to our community and stuff like that. So big up for that as well. About the Leeds Extended Reality Society, our main vision is to create some sort of bridge between students in academia and industry people, all related to XR fields. So we're trying to build this bridge and bring XR to the most number of people that we know. Also, we are also trying to democratize XR in some way. For example, we know that this technology is not very common. It's not very available to everyone. It's not a common technology yet. So we're trying to make it available to the most people that we know. And I'm very happy with the work we're doing in our society, because even though we are a technological company, I think we have a social role as well, especially because our founders are from medicine background and design background. So I think we have this holistic perspective of everything that we can do beyond technology. How can we impact the other stuff? And I think it's pretty great. Regarding this webinar, I just want to say that my expectations for this webinar are quite personal, because I want to start my own company at some point in the future. So every tip, every small skew that I can get along the way is so important to me. So I'll definitely be attentive to this webinar, and I hope that all the attendees here have some kind of have at least the same vision as I am, and at least the same will to learn as I do. And as a last point, I would love to give a shout out to our next conference, which will be in the 1st of August, hopefully, in which I hope that Marks and Clerks is present as well. And yeah, that's it.
Okay, thank you very much, Thomas. My name's Andrew Hartley. I'm one of the presenters today. I'm presenting with Graham Murray and Simon Portman. I'll just do a little bit of housekeeping before I get into the actual content. So hopefully that's flipped over for you as a slide there. Everyone's been muted just to stop feedback and that sort of thing. We're quite open to questions though, so if you want to ask a question at any time throughout the presentation, it's probably best if you do it in the text box, in the chat box, which you can see on the screen there. And then we've got Catherine, who's monitoring proceedings today. She'll collate the questions, and then probably at the end of each section we'll run through the questions and answer what we can. We're going to be quite tight on time, so maybe if we just do 1 or 2 questions per section, but we're always welcome to receive feedback and follow-up questions and follow up on any points that you want to. You also have the option of raising a hand, but I say it's probably going to be easiest if you can type questions, if that's okay. If you can't see the panel that I'm talking about there, then you can tap on the go to icon and then hit the white arrow in the orange box, and that should get you where you need to be. Okay, so as I say, I'm Andrew Hartley. I'm a chartered UK and European patent attorney. I'm based in our Birmingham office. So my job day to day is helping companies identify inventions, protecting those inventions through the various channels in the different countries. And then if it comes to it, trying to enforce those for clients where they need to do that. Graham is a trademark attorney. He's based in the Manchester office. He'll probably say a bit more about his role himself, but basically he does the same as I do, but for trademarks. And then Simon keeps everything hanging together on the commercial side. So he looks after the contracts and the relationships where you need to do something proactive with your IP, just to make sure it's all safe in a commercial context. So both myself, Graham and Simon will be talking today. I'll be talking about patents and patent filing strategies, and trying to give you some tips and hints that you could take forward and help direct you in the right direction that you need to be. So obviously, if you're an immersive tech startup, then you need very good value for money. You need cost-effective protection. You'll have limited budget to spend on IP, as most places do, but it's a lot more restrictive normally in an immersive tech company or any startup. So I'll give you some pointers towards that along the way, as well as giving an overview of IP, what the patent system is and that type of thing. Graham's going to talk about branding strategy. So again, it will be an overview of trademarks, how those can be applied in the right context. And then Simon's going to cover contractual issues and commercial considerations. As I say, we're open to questions, but please, with the important rider that you only ask easy ones and there are no difficult questions. So the different forms of IP, as a broad overview, there are two types. Principally, there are registered IP, where you have to apply to a given government office and have your IP registered to you, have it granted. So those are patents, designs, and trademarks. Patents cover technical processes and products. Designs cover the visual appearance of something, including some aspects of graphical user interfaces, that type of thing. And then trademarks protect the badge of origin, the goodwill, the relationship that exists from a company into the public, and how the public view that company. And then on the unregistered IP side, we have things that are created automatically. So if something subsists in a document as a work of art or literature, for example, then copyright would be attributed to that, and that would come into existence as soon as that thing is in existence. So as soon as you finish painting your picture or writing your latest novel, then you'd get copyright protection for that. Copyright is also used to protect software, which is relevant to this field, obviously, and that is in the sense that it's a work of literature, so the source code and the object code are protected by copyright. Database rights, that's kind of a right in its own sense, so that protects databases, as it says, pretty straightforward. And then there are certain types of design right which occur automatically. So that's similar to the registered designs, which protect the aesthetic appearance of an article, but they have different durations, the scope's slightly different. They're not quite as strong as registered designs, but it's a similar sort of, in essence, a similar sort of right. And then we've got confidential information at the bottom. So that is probably the most common form of intellectual property. Every company has loads of confidential information, and it stays like that as long as it stays within the company. As I say, we're going to talk about patents and trademarks principally, and then Simon's going to follow up with some commercial and contractual considerations at the back end. We can, of course, advise on these other aspects. Copyright does come into play quite a lot in immersive tech in terms of applications. So if you're doing a game for a VR set or some entertainment related aspect or something like that, then that often is covered by copyright. What we're more interested in here is the technology side, so the developing of the software and the hardware that feeds into the actual systems themselves, certainly from a patenting point of view, rather than the application side of things. Okay, so patents. Patents are a necessary commercial tool in most instances. They are expensive and are often underappreciated, particularly in this country. People are a lot more savvy on patents in the US and a lot more patent centric. Basically, what are they? They provide you with a legal right in its bluntest form, so you can go and sue somebody if they are infringing your patent. So if you've protected a product or a process and somebody else is using that product or process, and by using I mean making or selling or importing into a country, then you can go to a court and have that activity stopped, and you can ask for financial compensation, so financial damages and an award. So they're quite a powerful tool. One patent can cause huge devastation for a company in terms of its activity, but it's very expensive to litigate. So most patents aren't litigated. It's very rare that things actually go all the way to court. But what it does do is it gives you a tool which is, on the face of it, could be disruptive, and companies don't like disruption. They like certainty. So the presence of a patent gives you a way of negotiating some certainty for a company. So if you hold the patent for a product, let's say it's a VR display or something like that, then you could go and seek a license from a company and say, you can use our technology, you can buy our technology, you can make and distribute it, you can do what you like with it, but we want some financial compensation for that activity in the form of a royalty or whatever it might be. You could also block them and say, actually, no, we don't want you to use that technology. We want to sell it over here to another person for more money or whatever it may be. Or you may say, no, we want to keep it in-house and make it and sell it ourselves. So there's quite a potent right with a patent. Generally, that's kind of the front line. Generally, there are lots of secondary benefits. So we've listed some there. It can be a badge of innovation. So I used to work for a large engineering company, and they very much had filing targets that they used to like to hit because they thought it gave the impression that they were an innovative company and at the cutting edge of that particular technical field. And that applies, I think, to all companies. So startup companies in particular, if they have their own IP, they're in possession of their own technology, and they've got some ownership there and something to negotiate with. It can attract investment, so you can borrow against registered IP. It's an asset like any other asset is, and it can, in terms of getting funding, PV funding, that sort of thing, then it can be an attractive proposition for any investors. You can get corporation tax relief, so there's a thing called the patent box. So if you have a patented product, then your threshold of tax for the profits on that particular product are at a lower rate for having patent protection. So in essence, it's a commercial tool that you can apply however you want to. Your imagination really is your own limit when it comes to IP, and there are some fantastic uses and benefits, which we can't really touch on here in full, but obviously the world's your oyster, really. So in terms of what is a patent in itself, it is a solution to a problem. Basically, an invention is a solution to a problem. So you will be engineers of some sort, I imagine, and you will be looking to overcome problems, to solve solutions, to come up with the latest technology. And in doing so, along the way, you will be coming up with patentable inventions. There's no two ways about it in an engineering context. As I say, that they cover the technical aspect of things. So if it's to do with a technical solution, be it a product or a process, a method, then we can protect that with patents. In terms of technical subject matter, I'll explain a bit more about what you can and can't protect shortly. The fundamental criteria is that the invention must be new and it must be inventive. So it can't be an obvious modification of what's already known. Again, I'll say a little bit more about that in a second. Patents are territorial, so each country generally has its own system. So if you want protection in the UK, you apply to the UK Patent Office. If you need protection in the US, then you apply to the US Patent Office. This does add complexity and cost to the system, but it also allows you to apply for patents only where you want to. So it builds in a layer of flexibility into the system and lets you keep control of costs and adjust things as you go along as you need to adjust to your different markets. Patent term is quite long as it goes. It's 20 years. For immersive tech, that's probably quite long. It's longer than you'd probably need in most instances. But again, it's flexible, so you have to pay fees every year, renewal fees, and then if a market or a technology ceases to be of interest to you, then you stop paying those fees and effectively release that technology to the public, but then keep a handle on your costs a bit more. One of the downsides to patents is that they're published, so you could keep something as a trade secret, which we mentioned briefly at the start, and basically keep it in-house, don't tell anybody about it. If you do, then you have the necessary agreements surrounding it to protect it from a confidentiality point of view. But that has its own downsides, of which I won't go into in too much detail here, just for the sake of time. But the flip side is that you do have to publish. If you file a patent application, you have to be in possession of the invention, and you have to be able to explain it to an extent that somebody else can come along, take your patent application, just that document, and recreate your invention. So they tend to be generally quite high level, but yeah, there is that publication burden. And I say certain types of subject matter excluded, but I'll explain on that a bit more shortly. So when should you file and what sort of consideration should you have? That's very much a business application based question. There's no right or wrong answer to that, but the types of things that you need to be thinking about are the investment that you've put in a piece of technology. The patent system exists to encourage innovation, to encourage companies to invest in technology and develop new technologies. And the reward for doing that is that you can protect that technology. Nearly all businesses know instinctively what is the important technology, how important is it, and where is it going to apply, and then how much do we want to spend on protecting that with a patent or whatever right it might be. So there's a business case in most instances that, you know, do we want to spend money protecting this? Would we be better getting a patent application or spending more on marketing or product development, for example? And then there's a patenting side of the question, or a protection side, whereas do we want to spend money on protection? Is that going to be effective? Is it good patentable subject matter? Is there lots of prior art out there? How much territory are we going to be able to protect? Is it going to be a sliver on the last product development, or is it going to be a bit more of a land grab? So there are quite a few different questions we can ask ourselves on the patent side of things, and then questions that you can ask on your side to work out when you want to file something. Generally, the answer to the question is as soon as you possibly can. As soon as you're in a position where you feel like you're in possession of the technology, you know more or less what it's going to look like as a product that you're going to offer out to the public, then we should be trying to get some protection on that. It's a first to file system. So if you're the first person to file it, you get the protection, and that's generally worldwide. If somebody else beats you to that because you've said, oh no, we'll hold off for 6 months or 12 months and just see how it goes, then they'd get the protection. So, you know, a question is, how damaging would it be if you couldn't use the technology? Then you're better getting something on file sooner rather than later, and then getting your stake in the ground for that technology. Very quickly, the anatomy of a patent. They are very boring documents. We pride ourselves in being able to write unintelligibly and make things as difficult as we possibly can as a firm, as a profession of patent attorneys. If you do happen to look at them, then I would advise that you look at the background of the invention. So there's a description at the start, there's a background section which sets the scene and allows you to understand exactly what the technology is and the problem that they faced normally. There's a statement of invention which should have a title against it, which I would skip over, and then I would go to the detailed description, and that really tells you what's in a patent and what it's about. The claims are, from a legal perspective, the most important bit. That's right at the end of the document of the written section, and that defines the legal protection that's sought. So that's my job, is to write those things and then discuss those with the patent offices and get those in a shape where they can be granted. And then there's drawings at the back. Okay. So we draft our patent application. We get the claims, we get your sign off on it, we file it at the patent office. And then the first question really that's normally asked is it excluded subject matter? So I've touched upon software already. Generally, we can get patent protection for software in this immersive tech field if there's a technical effect, a technical advantage to the software. So if you've got code that improves the operation of a graphics processing unit or something like that, or audio, or reduces the noise levels in data processing, then we can generally get protection for that sort of subject matter. If it's more, I've created a new game or a new appearance for some sort of VR setup or whatever it might be, then that possibly isn't. That's more of an application base. We need the technical aspect and the effect that it has on the technical hardware that we're operating with, rather than it just being an aesthetic benefit, for example. Once we know that we are on solid ground with excluded subject matter, then we move to novelty, and that's a pretty easy question to answer. Has the invention existed anywhere in the world at any time before your filing date? It could have been an oral disclosure, so spoken conversation somewhere, or a presentation, a technical presentation to somebody. It could be a conversation that you've had with another organisation outside of confidential circumstances. So if you are having conversations with companies, then do make sure that you've got an NDA in place to preserve the confidentiality, and don't disclose something that would prevent you getting a patent application later on. Inventive step, that's probably what I spend most of my time arguing with patent offices, is something's new, that's fine, but is it an obvious modification of what's already known? There are various legal tests, and they vary slightly around the world, and it's not really advisable for applicants to get into that side of things. I think it's the message would be, if it's novel and it's important to your business, then let an attorney have a look at it, and then we can judge whether it's obvious. Engineers are very good at thinking what they've done is obvious, when actually from a patentability point of view it's not. What's important is that it's new and it's important to you, and then we can probably put some arguments together from a legal perspective to get it through the system where we can. Okay. A very quick overview of a filing strategy. So again, when I said at the start, a lot of this is about cost and how can you manage cost and keep costs down. This is a pretty typical strategy that we would apply to keep your costs down in the first instance, and then as you go on and you get more surety with your technology and you want to invest more in the IP protection side of things, we can start putting the cost or diverting the cost further downstream. So here we would file a UK patent application at 0 months. So that gives you your filing date. So anything that occurs before then is your prior art. We then, as part of that filing, we get a search report from the UK Patent Office. So they look at the invention, they go away and find prior art, and then they come back and say, we think your invention is not novel, it's not inventive, or it's fine, it can go through to grant. And at that point, we open a dialogue with them and try and work out some claims that we can get some patent protection for. Within 12 months, we've got the right to file in other countries. So let's say we have an initial application quite early on, and then we think, right, okay, we've got a bit more traction with that. After a year, we want to spend some more money. We can look at individual countries, so we can go for European or US, wherever it might be, or we can file an international patent application. Again, that defers the cost. So there's a one-off fee. It gets it through a certain stage of the prosecution, centralized with the international Patent Office, and then at the end of 31 months from the filing date, then we then break that into the different countries. So again, there's a mechanism there to delay costs a little bit and push it downstream. So that's one example of a strategy. There's lots of different strategies and lots of different ways you can do it for various situations. The idea is that eventually you'll get something granted in each of the countries, which you can then enforce further downstream. So where do you file? You could file in absolutely every different country in the world and have the best IP portfolio that you could ever imagine, but I can guarantee that you probably wouldn't have any money for anything else if you'd done that. So there are considerations as to where to get protection. So where are your main markets? Where are your competitors based? Where do you need to stop them operating? And if you're thinking of a licensing deal, developing technology for licensing purposes, which is commonly done, then where are those licenses going to exist? So for immersive tech, I've put down a nominal list there, which I would normally recommend to clients as a tier 1, Japan, US, Korea and Europe, and then tier 2, India, China, Taiwan and so on. And in doing that, we're looking at the main markets for this technology and where the main competitors are, and then tier 2 drops down on the level of those activities in those different countries and so on. It's highly unlikely as an immersive tech company that you would have such an expansive portfolio. What startup companies normally do is they have 1 or 2 key countries, which is very important to them, and then they rely on the protection in those countries. So for example, if you had a US patent and you've got the US covered off, that's probably enough to get you whatever you need out of that technology, whatever you need out of that IP, and anything else in other countries is an added layer of comfort, of luxury. If you're a bigger serious player, a bit more established, and your budget was greater, then you could look at very expansive portfolios like I've put down there. Okay. So one of the things, if you're starting up in a tech company, you might think, right, okay, we've got these different technical solutions that we want to progress, and we've got the different client bases that we can go to, the different customer bases. What do we spend our money on? How do we approach it? So I've said previously that we could look at a combination of trade secrets and patents and go forward with those, or we could do a sort of scattergun approach and have patents for different things in different areas. I'm working with a company at the moment, actually I was talking to earlier today, and they are in a situation there. It's not immersive tech, it's composite braidings, so making composite structures, and they are looking at converting from an engineering consultancy model where they've been doing one-off solutions for customers, and moving to a licensing model where they build platform technology, and then patent that, and then send that out into the market and actually push that into the market as technology. So they've got options of patenting their one-off customer solutions. They've got the option of patenting different platform technologies, of which they've got 2 or 3. They've got methods of manufacture which are generic to everything that they do, which again they could patent, or they could keep that as a trade secret. So in this instance, I mean that's very particular to that business. So if for example on the slide there we've got product A, product B, product C, I might advise, for example, that we could protect those 3 products. Let's have a patent application for each of them, and then writing that patent for each of those, we end up with a circle of protection around it. So any of that technological field that surrounds that product, we'll try and get protection for. So we don't normally file just for the unique product itself. We normally try and get the underlying inventive concept, and make the most that we possibly can. Then during prosecution, so when we're talking with the patent offices, I said earlier that they go off and find prior art and then come back to us and say it's not novel, it's not inventive. Then we can, at that point, look at the blue dots, which are the prior art, see which fall within the definition of our invention. So for product A there, we've got a couple of bits of prior art which have fallen in what we've asked for as protection, but don't directly overlap the products that we're looking at protecting. The same with product B, and then product C actually looks to be in the clear, so we can get some very broad protection for that concept. So what we do in prosecution then is trim down and protect the actual concepts that we want to. At that stage, or anywhere along that journey, you might look at your portfolio and say, well, actually, we filed quite broad in that instance for product A. We're not actually that interested in that smaller scope of protection, but so we'll drop that one, we'll let it go, but we'll carry on with product C. So it's not uncommon to file very broadly in the first instance and pursue multiple strands, particularly if you're not sure where you're going to end up in 2, 3, 4 years time, and then filter it down later on and trim it down and manage costs in that respect. And it's a worthwhile activity, is going through that regular review process, if you are in that position. So as a few sort of pointers, I think I've probably touched on much of this already. So different areas of technology require different territorial coverage. So part of your business analysis will be to be aware of where is important in terms of IP for that technology, and we can do research and from the IP side of things and find that out for you. We can work on that type of thing, and then to have an awareness of your inventions as well. So obviously I think most businesses would do this as a matter of course, but you know which your crown jewels are, you know where your main revenue is going to come from in the foreseeable sort of 2 or 3 years, where your exit strategy might be and what you need for that. So it's just keeping a handle on that side of things. And then business environment changes. Yeah, again, it's not a similar sort of point. It's just making sure that you've got a fit for purpose portfolio, and making sure that you're on top of that side of things. Technology changes. It's very hard to evergreen patent portfolio. So it happens in pharma quite a little bit, pharmaceuticals, where they get to the end of the 20-year term and they want to renew that patent family, and so developing technology for the sake of it to get you IP protection is one method that you could do, but just keeping an eye on how technology changes. Yeah, so we've said how new design rounds become possible. Have you captured the market? Is your patent portfolio still fresh and relevant to the technology as it's developed in your company and outside of your company, for the duration of that protection? So I've spoken a little bit there about the way that we can sort of refresh things and keep it on track and stuff, and I think this is saying much the same on this slide. Pick your country of first filing very carefully. I think that's absolutely correct. Normally we go for a UK filing as the first one because it's very cost effective, it's very cheap. You get the indication from the Patent Office very quickly as to whether it's patentable, and they don't charge a lot of money for that service at all, certainly less than the US and the European Patent Office do. So UK is more or less a default normally for UK companies, and then we can expand out from there afterwards. I think the other points actually on there I've already covered. I've jumped the gun, I think. So yeah, I think generally in small companies, the second to last point there, so get R&D involved in the patent prosecution. I think that's good. Patent attorneys are very competent normally in terms of technology. We all have a technical background and would understand the technology for the most part that we're working in. We only work in the technologies that we're familiar with, but getting some cutting edge advice. Obviously, we're working on brand new concepts by definition because we're going for patent protection. So getting the correct technical information from within the business is worthwhile. And invention harvesting as well. So there are, in all businesses, there's lots of inventions kicking around, there's lots of IP, and then companies generally just pick out the ones that they think they want protection for. But actually there's a lot to be said for having a database or a collection of documents which record inventions and IP which aren't necessarily going to end up in patent protection. They can be assets in their own right. I have worked for companies before where the thing that was really attractive to the person buying this company was the stuff that they'd got in the back room in the locker. It wasn't the stuff that they'd filed for. It was all the IP and the ideas that they'd generated and that know-how that they've managed to capture. So we had a long register of ideas that we've got protection for, register of ideas that we hadn't got protection for, but we've got the information for, which had inherent value as an intangible asset for the company. So do make a point and get into the habit of recording and capturing innovation and technology as you go along. So take-home points, yeah, so go on, make sure you capture your ideas, invention disclosure forms, that sort of thing. Obviously, we can provide more advice on that if you wanted to. If you're in that situation, we can provide you with templates and the like, so you can capture information. Let us know, or let a patent attorney know if you're coming up with new stuff and it's important to the company, and we can take a look at that and see if it's eligible for you. That's no problem. And yeah, so remember that patents are evolutions, not revolutions. I think that's a very important point. I've been doing this job for 15 plus years now, and I'd say I've only ever seen 2 or 3 what I would say was step changes in technology. Most patents, nearly all patents, are very incremental steps in technology. So don't expect a massive eureka moment and then think only that would be patentable. It is about these step changes. That's where your value often comes from. So it's the smaller stuff that counts often. And again, as I've just said then, even an application that is ultimately never granted can be of commercial benefit. So that's true of data that you capture and keep in the back room, but also having a pending application can be as valuable as having something that's granted. So the difference between pending and granted is that if it's pending, you're still discussing it with the Patent Office and agreeing what can be granted for an invention, whereas a granted one is something that you can enforce, where the Patent Office says, right, that's been granted, you can now take people to court if you want to. There's a lot of benefit in just having something patent pending, a lot of the secondary benefits that we spoke about right at the start. So the marketing benefits of looking innovative and gaining licensing and that sort of thing, and investment can all be done with patent pending stuff. So there's not actually a commitment to keep something until it's granted and take it forward. You can just have it for a short period of time as you go along. And then maintain confidentiality. So as I said, when I was talking about the 3 gates that we pass through, confidentiality is king in IP. Keep control of your IP. Don't let it out of your sight unless it's in very controlled circumstances. And I think Simon will probably be saying more about that sort of thing later on in terms of how to operate in those situations. So I think on that's the end of patent. Sorry, it was a very quick whistle through. I'm conscious that we're very tight on time. Can I just ask if there's been any questions? It doesn't look like it at this stage, so that's absolutely fine. If you do have any questions or you want to get more into the detail of the specifics, then you can drop me a note later. I think we're circulating the email addresses if we've not already. On that point, I shall hand over to my learned colleague, Graham, to take over. And hopefully that should transition across. Oh, okay. So I think I press no. Oh, that's it. Have you got that, Graham? Are you there?
Yes, thanks, Andrew. Just bear with me while I share my slides, guys. Okay, so you should all be able to see the beginning of my slides here. My name is Graham Murray. I'm a chartered trademark attorney at the Marks & Clark Manchester office, and I just wanted to talk to you today about brand strategy and trademarks. As a trademark attorney, my role is essentially to advise clients on the selection, protection, and enforcement of their brands. And I intend to cover a few key points for you to bear in mind in today's session. So we will discuss what a trademark is and how a trademark can be protected. We'll discuss the benefits of registering a trademark. So, what does a trademark registration give you? We'll then touch upon the implementation of a brand protection strategy within your business. So we'll look at the development, protection, and enforcement of trademarks, and we'll look at how you can avoid infringement of third-party trademarks, which is a key consideration. And then towards the end, I will just briefly touch upon some trademark considerations which are relevant in the immersive tech space. So to begin, I thought I would start out with a definition of a trademark in the UK and EU. So a registered trademark in the EU will protect any sign which is capable of being represented in a manner which enables the public to determine the clear and precise subject matter of the protection and distinguishes the goods and services of one undertaking from those of other undertakings. So essentially what this means is that if you are using a sign in the course of trade and your customers identify that sign with your business, then that sign should be capable of being registered as a trademark, subject to some requirements which I'll discuss later on. And it's important that if you do have signs of that nature that you're using in the course of trade, that you consider registering them accordingly. So, as opposed to patents, you'll probably be more aware of trademarks, given that you are confronted with them on a day-to-day basis. But there are certain requirements that you need to be aware of if you're considering registering trademarks. So a trademark can be registered in the UK and EU for various forms. So a brand name is obviously the key thing. Volvo is the example I've used there. Volvo will be registered for that brand name in the UK and EU. But also, obviously, logos can also be registered as trademarks. So we've used the Adidas example there. We also, commonly see other logos registered, the Nike swoosh, for example. In addition to those very common trademark types, there are also additional types of trademarks which are, in certain circumstances, capable of registration, such as the shape of a product, a position mark, i.e., in the example there, the exact position that red line is attached to that training shoe could foreseeably be registered as a trademark. Patterns would be capable of being registered as trademarks. And again, in other circumstances, single colors or color combinations. But the key to registration is that whatever you are seeking to register is distinctive. Now, what does that mean? Essentially, that means that the consumer will identify the mark that you're seeking to claim exclusive rights to as an indication that your goods and services that you're offering under that sign emanate from your business and from your business alone. So they must overcome that threshold of distinctiveness in order to be capable of registration, and I'll touch upon that in a little more detail later on. And going hand in hand with this requirement that trademarks are distinctive in order to be capable of registration, they can neither be descriptive or generic terms. So as an example, if you were selling a soap product, for example, and you called it super soap, and you were trying to register the term super soap as a trademark, given that that essentially describes what is a very, very good soap, you wouldn't be able to register that in the UK and EU and in most territories worldwide. So when you're developing brands, you need to bear this in mind. It's essential that the brands that you develop are distinctive and they don't describe the nature of the goods and services that you offer. And touching upon that final point where I refer to marks being generic, neither should they be generic terms in your industry. That being said, if you have used a trademark in the UK or EU for a significant number of years, to the extent that you have educated the consumer to identify what is on the face of it a descriptive or non-distinctive trademark with your business, then in certain circumstances, that trademark may be capable of registration on the basis that it has acquired distinctive character. So even in those circumstances, all is not lost, and it's important to take advice if you feel that you have a descriptive term but your customers associate that with your business. So what is a trademark registration? What is the process? Well, a trademark registration protects the trademark in question for the goods and services that you claim in your trademark application. So using the Pokemon trademark here as an example, if you were seeking to register that trademark in the UK, you would file an application. The application would include an example of that trademark, and you would also refer to the goods and services that you wanted to protect that trademark for. The goods and services fall into 45 classes, and it's essential that you have a discussion with the trademark attorney prior to filing an application in order to ascertain which classes your goods and services would fall into. That Pokemon mark would most likely be registered in class 9, which would cover things like software, but also given the merchandising relevance of the Pokemon brand, it's likely that they would also seek to protect that in class 25, for example, which covers clothing. It may also be protected in class 28, which covers things like toys. So these are all important considerations when you're filing a trademark application. One of the many pitfalls that we see are new businesses filing for what they consider to be the core product or their core service, and they don't bear in mind how their business can expand in future. So it's important to bear that in mind if you're filing trademark applications. The second point is that trademark registration is done on a territory by territory basis. You have to register your trademark in each territory of interest to you in order to obtain a registration. There are various methods for obtaining registration worldwide. In the UK, you would file an application directly at the UK Trademark Office. In the EU, you would file an application at the EU IPO. An EU trademark registration grants you a registered trademark, which is enforceable throughout all member states of the EU. There's also the international trademark system, which is essentially an administrative system which allows you to file a single application at the International Trademark Office, designating any territories worldwide of interest to you which are party to that international system. That can be quite a cost-efficient way of doing things. In addition to that, though, you can also file directly at national offices worldwide. So, for example, for various strategic reasons, you may decide to use the international system to register in the US, China, Australia, or you may decide to file directly at each national office in those territories. And once you file the trademark application, it will be examined to determine whether or not it's capable of registration. So the examiner at a UK trademark office will receive your application and consider the issues that I discussed at the beginning. So is the mark sufficiently distinctive to render it capable of registration? If they don't believe that it's sufficiently distinctive, or if it's descriptive, or if they raise another issue, then they would issue an objection. At that stage, all is not lost, though. It's still possible to file arguments to seek to overcome an objection. Once it's progressed through examination, whether you've been able to successfully overcome an objection or whether it sails through without any objection, it will proceed to publication. What this essentially means is that it's published. The publication is a matter of public record, and any third parties who may seek to take issue with the registration of your mark can do so if they decide to file an opposition, or they may write to you in the first instance and say, we own rights to something which we believe conflicts with the mark that you've sought to register, and they may ask you to withdraw your application at that stage. If no oppositions or objections are raised, then you secure a trademark registration in the territory that you filed the application in. Just bear with me here, I'm having a slight issue with my there. So I'm going to move on to discuss brand strategy in more detail, but I thought I would just briefly touch upon unregistered trademark rights as well. So alongside trademark registrations, you will also acquire rights to your trademarks by virtue of your use of the trademarks in the marketplace, in the UK and in other territories. And those rights can also be relied upon. So let's say, for the sake of an example, if you haven't registered your trademark, which obviously we would recommend you do, but if you haven't registered your trademark, but you've been using the trademark in question in the UK for 5 years, you will have acquired rights to that trademark, and they can be relied upon in certain circumstances to prevent third-party use of your trademark. And in the UK, that's protected by the law of passing off. And in other territories, there are similar unfair competition rights which can be relied upon. So it's important, just as a background, to be aware of that unregistered trademark position too. But as a trademark attorney, obviously, I advise my clients that they should seek to register their trademarks. Why should you do that? Well, in the first instance, it gives you an exclusive right in relation to the goods and services that you've sought to protect it for. So if you have a registration for one of your key products and you've registered the product name for the goods that it's used for, the trademark registration allows you to prevent third-party use. And it's a relatively broad right, so it allows you to prevent third-party use of an identical trademark for identical goods and services. But it also allows you to prevent third-party use of similar trademarks for identical or similar goods and services if the consumer is likely to be confused. And in certain circumstances, if your trademark which is registered enjoys a reputation in the UK or EU, you can also prevent third-party use for dissimilar goods and services. So it's a very strong right. And by virtue of the fact that it's registered, it's easier to protect and enforce. So whilst all is not lost if you're seeking to rely upon unregistered trademark rights, if you do find yourself in a position where you don't own a trademark registration, it's going to be more expensive to rely upon unregistered trademark rights. The primary reason for that is because if you have a trademark registration, you have a piece of paper you can refer the third party to, you can send them a letter and tell them you own the registration and you want them to stop using your trademark. If you're relying on unregistered trademark rights, there's a very high evidential burden that you have to overcome in order to prove that you own those rights. So therefore, the cost of discussing your case with lawyers, obtaining that evidence, etc., is higher. Trademark rights, trademark registrations are renewable indefinitely, so you can continue to renew your trademark registration every 10 years, provided that you pay the relevant renewal fee. They act as a deterrent to infringers. So a trademark registration is a matter of public record. It sits on the register, and it may be that your competitors are considering entering the marketplace with a trademark which is similar to yours. They may conduct some searches prior to adopting their own trademark, and it's very likely that they will be aware of your prior registration, so it can act as an immediate deterrent to put people off, so it can really block people entering into your space under identical or similar brands. It's a valuable commercial asset, so in the same way as Andrew touched upon with regard to patents, it's an intangible asset. It can accumulate financial value over time. It can be sold. It can be licensed for the relevant fees, etc. And in addition to that value, it can act as an attraction to investors. So if you're seeking to sell your business, or you're speaking to investors, then if you have a strong portfolio of trademark registrations, then that's always going to put you in a stronger position, and it's going to increase the value of the company accordingly. So in terms of brand strategy, these are the real take-home points that I wanted to touch upon today. So you need to consider developing strong, distinctive trademarks. This increases the value of the brand itself, and it increases the chance of that trademark being capable of registration. So the two things go hand in hand. When you're developing trademarks, if you have a marketing team which are developing trademarks or product and service names for you, make sure that they're aware of these requirements. There's no point them coming to you with a highly descriptive trademark, because one, it's not going to differentiate from your competitors in the marketplace because it's descriptive, and two, it won't be capable of registration. So you're never going to be in a strong position to prevent third parties from using your trademark. The second point I wanted to touch upon was the importance of protecting your trademarks in the territories of commercial importance to you, and it's important that you build that into your IP strategy as a whole. So one of the benefits of trademarks is that trademark registration, is that you don't need to file applications all at the same time. So you could file in your core market, the UK first, and then as your business grows, you could stagger your filings and file in territories worldwide accordingly. It's also important that you review your portfolio and update protection if necessary. So let's say today you filed an application for where you consider your business expanding in the next few years, but 2 to 3 years down the line, you moved into an entirely different commercial space and you were selling entirely different products under the same trademark. It's still possible to re-register that trademark for the expanded range of goods. So it's important that you regularly review your portfolio to make sure that it adequately protects what your business is doing at that time. This essentially shows the line of distinctiveness. So as I said, it's important that you develop strong trademarks, and the green arrow at the end would be an inventive trademark, which means nothing in relation to the goods and services that you're seeking to register it for. I think a good example would be Kodak. So whilst the Kodak business is no longer a roaring success, as a trademark, it's a fantastic trademark. It's entirely inventive. There's no reference to the goods and services that it's used for, and therefore is a really strong, valuable brand that was easily capable of being registered. In the middle there sits elusive trademark. So in certain circumstances, if a trademark contains words which may be relevant to the area that you're operating in, it could still be capable of being registered. So it's important that you have that discussion with the trademark attorney. And then towards the end, obviously, sit descriptive and generic marks, which I've already discussed. On the face of it, they're going to be very difficult to protect. Okay. So once you've registered your trademarks and you have your portfolio in place, that's not the end of the story, because it's important that you also seek to maintain your portfolio and enforce your registrations accordingly. So first and foremost, in most territories, after a certain number of years, in the UK and EU, it's 5 years. If you wish to enforce your registered trademark, you have to show that you've used the trademark in question for the goods or services for which you've registered it for. So it's important that you use the trademark and use it consistently. Always use it in the same way that it's been registered. Always use the R symbol, etc., etc. And with that in mind, you should keep records of your use, because if you do seek to enforce a registered right and the registration in question is subject to proof of use, then you will need to submit evidence of that use. So you need to keep records of that use. You need to show where you've used the trademark, the date that it was used, what it was used for. Going hand in hand with that are records of achievement. So if your product has won awards, or you've been referred to in press or industry articles, it's important that you also ask your marketing department to keep dated records of evidence of that nature, because it's always going to put you in a stronger position to enforce your rights further down the line. The second point there on this slide refers to watching services. If you have a registered trademark, it's also important that you consider instructing a trademark agent to conduct a watching service on your behalf. That will identify any third-party applications that are filed in territories that you designate, so usually the territories of commercial interest to you, and it allows your trademark attorney to put you on notice, gives you time to take action if you need to. You should also educate your staff. Your staff are going to be, engaging with competitors, reviewing what competitors are doing, on a day-to-day basis. So make sure that they're aware of what you own, make sure that they know what you've registered, and make sure that they know to bring to your attention any third-party use of your marks, so that you're able to take action accordingly. I've already touched upon that reviewing your portfolios point. Again, I would stress that that's of immense importance, just to ensure that you have everything in place and that you're registered for everything that you're doing. So in addition to all of the points that I've made about registering trademarks, I would also really highlight that clearance is key. What does that mean? Well, if you're considering adopting a new brand, before you commence use of that brand and before you seek to register it, it's important that you conduct some clearance searches in order to ascertain whether or not there is any risk associated with your use of that trademark. So, for example, if you have a new product and you come up with a distinctive trademark, before you use it, you need to make sure that no one else has registered that trademark, and or that no one else has registered a similar mark. Because if they have and you commence use of that mark in the UK and somebody owns a UK registration for that trademark, there's a high risk that your use would infringe that trademark registration, and that the third party could contact you and ask you to cease use and or commence infringement proceedings. Now, even if they don't commence infringement proceedings and it doesn't go to court, if they write to you and say that they own an earlier trademark registration and you're using an identical mark, obviously that could cause significant problems for your business. It may be that you've got to recall products, it may be that you have to destroy products to which the brand has been applied. You may have to undertake a rebranding exercise and incur all of the associated costs. So whilst it's important to be developing distinctive trademarks that are capable of registration, before you even enter the market or seek to register your trademarks, you should be conducting some searches. It gives you increased confidence. You can use your mark with freedom in the marketplace without the threat of infringement hanging over your head. It saves on costs, because if you filed a significant number of trademark applications worldwide without conducting any searches, then obviously if issues arise later on, it's difficult to recoup any of the costs associated with filing trademark applications. And it also avoids unnecessary opposition. So as I mentioned earlier, once you've filed an application, third parties may be in a position to oppose your application. But if you've done upfront searches before you do any of this, then you would hopefully be aware of any potential problems. Now, startups, may not necessarily be in a position to instruct a trademark attorney to conduct a search on their behalf. I would always recommend that you do consider having a conversation with the trademark attorney and getting some costs around searches. If you're not in a position to do that, at the very least, you should conduct your own searches before you start using a trademark. So put your chosen trademark into Google. If you see a competitor using something similar or identical, then obviously immediately there's a potential problem there, and you could seek advice from a trademark attorney at that point. You can also, look at the UK Trademark Register. The UK IPO website would allow you to enter the chosen trademark, and you can see whether or not somebody's registered it already. So even if you're not going to engage with a trademark attorney, which I would obviously advise that you do, there are things that you can do yourself to lower the risk associated with infringing third-party rights. In terms of take-home message, I think that for startups in the immersive tech space, clearing your brands is really important, because we regularly see clients who come to us after they've launched. They haven't conducted any pre-filing searches or pre-use searches before they launch, and our advice in the main is that if somebody else has already got a registration and it's a enforceable registration, then it's going to be very difficult for us to do anything, and the client may have to consider rebranding or doing some sort of deal, etc. So take-home message, clearance is very, very important. Finally, I just wanted to touch upon trademarks in your space. So there are some additional considerations that I thought were relevant to your sector. If you're operating in a VR, AR environment and you're using third-party trademark registrations, then you need to be aware that they can still infringe those, the use of a third-party trademark which is registered can still infringe that registration, even if it's done in a virtual space. So, for example, if you have a virtual environment and you have a storefront within that environment and you're using a Tesco trademark, arguably that would constitute use in the course of trade, and Tesco could take that action to prevent that use. So it's important that if you are considering using third-party brands in an immersive environment, you should take advice before you start using those trademarks in that environment, because you can find yourself in hot water later on. In terms of your registration strategy, you should also ensure that you future-proof your trademark filing. So obviously immersive technologies can have applicability in a significant range of industries: healthcare, gaming, manufacturing, film and entertainment, cybersecurity. So if you have a piece of software which you're currently just using in the gaming industry, feasibly that may be relevant to healthcare later on. It's actually very common for gaming entities operating in this sector to move into healthcare later on. I've seen that quite regularly. So when you file your trademark applications, you need to bear in mind how your business could grow and expand as you move forward, and try to tick off all of the potential industries that you foreseeably see the brand entering into in the future. Finally, in your space, in addition to the range of trademarks that are capable of registration that I outlined at the beginning of the talk, there are also some non-traditional trademarks which in certain circumstances could also be registrable. And I just wanted to give you some examples of those sort of registrations. So in the UK and EU, it's possible to register motion trademarks. They essentially consist of a movement or a change in the position of elements of a trademark. I'm just going to show you an example. So this is essentially a movable logo, which is registered in the EU. Obviously, it's a Vodafone trademark. And you will see that in addition to that, we can also register multimedia trademarks, again, very relevant in your space. So this would be a combination of image and sound. Again, this is a trademark which is registered in the EU. The important thing about the first two examples is that they are distinctive. So touching back on my previous point, they enable the consumer of the services of interest to the people that own those registrations to immediately identify those trademarks with their owners. And they act as origin indicators accordingly. This example is a trademark which is currently pending at the EU IPO. So someone's applied to register it as a trademark, but it's currently undergoing examination. I'm just going to play it and then I will discuss it in more detail. So you can see that that would arguably be relevant to similar environments in a VR space. However, I would anticipate that this trademark application will be refused because it's not, in my view, sufficiently precise to operate as a sign in the course of trade. You know, it doesn't, in my view, indicate to the consumer that this is a trademark. Maybe that in certain circumstances, a shorter clip, for example, just the bullet through guys heavily sufficient to render a clip of that nature capable of being registered. But I think this longer clip is arguably unlikely to be capable of registration. But it just shows that, you know, people in this space are seeking to broaden out what they're seeking to register as trademarks in order to acquire forms of IP rights that they can enforce against their party. So, you know, you just need to bear that in mind. And if you do think that you've developed something, or, you know, something in an environment which you think, you know, this is distinctive, our customers know that this emanates from us, this originates from us, then you should at the very least speak to a trademark attorney just to get their opinion. Another non-traditional trademark would be a sound. Again, this is obviously relevant to your space if you're producing sounds in a XR environment. So again, that's a trademark which is registered in the EU for that sound, on the basis that when the consumer hears that sound, they immediately identify it with the owner of the registration. That takes me to the end. I'm going to see whether or not we have any questions. And I can see that we have one question. So many brands in immersive tech use very similar descriptive terms, i.e. VR, immersive, and so on in their company product name. Should that be avoided by startups? Well, what I would say is that as long as those descriptive terms are used in combination with a distinctive trademark, so the name of your company followed by VR, or the name of your company followed by immersive, it's likely that the term as a whole will be capable of registration. So if you're using it in combination with distinctive terms, then it's unlikely to cause any problems. I wouldn't necessarily say that you avoid that approach. I hope that answers the question, but feel free to fire anything further. I'll give you a couple of seconds before I hand over to Simon. Okay, happy to take more questions at the end anyway, so I'll now pass over to Simon. I'm just going to do that now. There we go, you should have that now, Simon.
Okay. Can you see my screen? Right, we're overrunning a bit, so I'll be as quick as I can. Yeah, I'm a commercial lawyer. I advise on things like commercial contracts. So for an immersive tech company, that would be things like making sure you own your IP, R&D collaborations, manufacture, distribution, licensing, and that sort of thing. So I'm going to give you a few pointers on the sort of problems that a VR startup might come across. I'm not going to go into too much detail about individual types of contract. That might be a session for another day, because depending on what you're doing, whether it's providing hardware or software or content, you might be involved in different types of contract. So I'm going to talk about some general lessons today. So I think we I don't know what it's like with you, but I know we've got some people watching this from all over the world, but certainly in the UK, when you buy a house, it gets more and more difficult. And when you sell a house, it gets more and more difficult. There is more and more that you have to comply with in terms of regulations, having the paperwork, the necessary approvals, and so forth. And that's pretty much the same with a company. Just in the same way as if you sell a house, the buyer's lawyer will crawl over everything to see if you've got the right paperwork, to see if there are any ambiguities to boundaries, to see that you've got the right permits and so forth. In the same way, if you sell a company, the buyer's lawyers are going to crawl over everything in connection with it. And the procedure can be a complete nightmare. As a result, it's a really good idea from day one to act like you're going to sell the company. And from day one to talk to the people that might want to buy it. They're probably going to be your customers or licensees anyway, and take tips from them. Because even if you don't sell the company, doing all these things and doing a proper job from day one is going to make your life a lot easier just in running the business. We get a lot of companies through the door, and we've heard about how important the technology is, and it is important, and getting a branding right. We can't normally tell if a company is going to fail because the technology isn't patentable or it's not going to work. But we can usually tell if it's going to fail because of the people, and you find out very early. If they don't get on and before the day is up, they are arguing with each other and trying to instruct you behind their backs because they have a different idea of who should get what shareholding or who should be in charge of what, then it's going to fail. Also, it may be clear if they don't know what they're doing. People starting up a company, if they haven't been in this area before, even if they're very technically good, may need to hire people who have experience in putting together commercial deals, marketing, have the right contacts in the industry, and so forth. So you're going to need to hire those people in. Also, is there anyone in the organisation that you don't need? Beware of the best friend of the CEO who actually doesn't bring anything to the party at all. And normally when you come through tough times, you can see who in the organisation isn't actually pulling their weight. Another thing that can happen is people in an organisation don't get on with outsiders, so it's not much use having really great products, really great technology, if you can't actually get on with your potential customers, licensees and investors, whatever. We once had a client, it was a startup, the technology was brilliant. It wasn't quite as good as time travel, but it was nearly that good. But the inventor just couldn't get on with people. He was always arguing with his colleagues. I ended up arguing with him. When he went to see investors, he spent most of his time showing how much cleverer he was than them. And as you can imagine, that's no use. Also, often the people that have come up with an idea are the last people that should be allowed to try and market it. They might not be able to talk about things in an engaging and easily understood way, so it might be then have to get other people in to sell the product for you. And sometimes, it can be difficult if it's your idea and you've, originated the technology to actually realise that maybe you've got to give up control up to a point and someone else should go out there and try and sell it for you. So don't be too proud. Another thing is, it's all very well having a brilliant idea, brilliant technology, but you've got to get it out there. Look at your potential customers and licensees. How do you get to know the people there? It's not much use thinking, Google or Microsoft or Hewlett Packard, they're a great company to go to, and then just contacting them via the website. You need to find out who the right people are to contact in that organisation. And the good way often to do this is sometimes you look on social media find out and search in terms of name and job titles to find people, but also go to events, use the partnering facilities to, you know, contact the people who are going to be at those events, because normally it's the decision makers that turn up and you can get in front of them. Or we hope that you will be able to get in front of them when we're all allowed to travel again. And remember also, don't just attend XR events. There's not much point in a whole load of startup XR companies who are exactly at the same level in terms of the pipeline, all going to an event and they're all standing next to each other in an exhibition hall. If you have some technology which could be used in the education sector, then you should go to education conferences. If it could be used in the healthcare sector, then you should be going to healthcare conferences. If it could be relevant in computer games, then you should go to those conferences. So, you know, they're not necessarily immersive tech events that you should be targeting. And as I said, you know, look at making sure that you have the right personnel as well to access the market. That may not just mean employing new staff, and in this regard, the sort of person that is most missing from a startup tends to be a business development person in that specific area. So, you know, that means, you know, if you're an immersive tech company and you're looking to supply training to the medical sector, you need to get someone who's a marketing person with experience in that sector. It's not much use having somebody who knows about XR, but their experience is all in entertainment. Alternatively, you might need to get access to that market by appointing an agent or a distributor who can, you know, get to that market. Either an agent will get you customers and you pay them commission, or you sell the product to a distributor. It might be a software reseller, and then you sell it into the target market. As I said earlier, keep, you know, organize the company like you're always going to sell it or get investment. So keep good records, keep them filed copies, they're easy to look at. Always review your patent portfolio and your strategy with your patent and trademark attorney. As Andy said earlier, keep things confidential so you don't destroy patentability. Organize your diary so that key dates like patent renewal or trademark renewal dates or contract renewal or termination dates are in there, so you get a reminder some weeks ahead and you don't miss a deadline. You're going to also need to comply with regulations in your sector. We'll talk about this in a bit more detail later. And finally, have appropriate policies in place. And that doesn't just mean, you know, the health and safety policy and the other HR policies. It means having an IP and IT security policy in place. So as I said earlier, you don't do something that ruins your patentability of your technology. You don't breach confidentiality, or you're not borrowing something off the internet for your marketing material so that you end up being sued for breach of copyright. Once you come to investment or selling the company, you know, always look and see there are going to be some problems there, but you know, try and sort them out before you end up selling the company. So there might be things like you've had some content supplied or some software written for you, and the party in question never transferred ownership to you. It's far easier to make sure in the contract at the time that they've done this, rather than you have to go back to them at a later date and say, look, we're about to get investment. Please can I have an assignment of the copyright in this? Because at that stage they might say, well, how much is it worth to you? So, you know, get things right at the time, because it's much easier than sorting them out at a later date. And if you don't sort them, if you have to sort them out when you're going for investment or selling the company, it can hold things up for a long time. And remember, you know, you just shouldn't know about, you know, technically your area in terms of immersive technology in your market. If you have a company, you need to know about company law, about the filing requirements and the tax requirements. You're going to have employees. You need to know what your liability is to them in your country. The directors in your company are going to have a higher level of responsibility to the company than just employees will. and they could be liable if they're in breach of that duty. So if you're going to be a director of that company, you need to be aware of what your duties are. You could be processing personal data, not just of employees, but if you're capturing images of people in your product. If you say you have a product that diagnoses or treats a medical condition, you're going to be storing patient data. So you need to know what your legal obligations are regarding storing that data and where you need to get consent from the data subject. If you're advertising your product, you need to be accurate, not misleading. You've got to comply with the trading standards. Otherwise, you can find that the regulatory authorities will come after you. And more often than not, this is not because your customers complain about you, it's because your competitors are looking at what you're doing. And if there is anything that is not compliant, then they like to report you. In the same way, if you're selling anything online, then there may be extra regulations in terms of what information you must give about the company, the right of cancellation that the customer may have. And again, if your website is not compliant, then the regulatory authorities might notice this, or you might get reported by someone. Remember also that you could be operating in an area with particular standards. So, you know, if you are operating in terms of medical diagnosis, it could well be that your immersive tech product, which otherwise would just be a bit of software or an app, could qualify as a category of medical device. And you need to know then what sort of regulations you have to comply with before you can sell in any given territory. You may need insurance because if you sell your product and it turns out that it might be defective and the customer comes after you because of that, because it suffers loss, or because there are allegations that you are infringing someone else's intellectual property, because they say you're infringing their patents, or you borrowed their content, or you're using their brand without permission, you could get sued. So you may need to look at what sort of insurance cover you can get. And if that costs money, then you might have to factor that into the fact that you're going to be charging your customers more. Another thing that's happening a lot at the moment, as you've probably heard, is because we're all working remotely, there are a lot of attacks by malware, hackers, and so forth. So you need to make sure that, as well as having the correct software protection in place for this, that your employees, as part of your IT and IP security policy, know what to look out for, you know, what they shouldn't be downloading, what emails and attachments they shouldn't be opening, and so forth. And also, it might be appropriate for you to get cybersecurity insurance, because one of these things can do you immense damage. You know, if you've got someone who then basically shuts you out of your system or your database and will only let you back in if you give them thousands of pounds in Bitcoin, then that can be very damaging. You want to be entering into contracts from day one. It's amazing when we look at clients who've got quite a long way down the road, how often they don't have any contracts at all. And as you can imagine, if that's the case and there is a dispute, then you know, how can you prove what was agreed? What people sometimes don't realise is that verbal contracts, apart from when you're doing things like transferring patents or trademarks on land, can be legally binding. But the trouble is, of course, with a verbal contract, is how do you prove again who said what? I once had a client and they were telling me they wanted to talk about the other side, about possible breaches of a research agreement, but there was nothing in writing, and the only proof was that my client had discussed it with someone on the other side who was now on maternity leave. Luckily, when she was phoned up, she confirmed that all this was the case. She remembered it exactly the same, and it was, and we were luckily able to put everything in a written contract so that we reflected what was going on in the first place. Badly worded contracts, minimalist contracts. Be very wary trying to save money. just by writing your own contracts. There is a reason why lawyers are used for this sort of thing, because they know that if you know how to word these contracts so that you can minimize ambiguity, because if there is any ambiguity in there, there is more scope for there to be a dispute. Another thing is be wary, because you're so desperate to get the deal, of signing any contract that's put in front of you, because for a start, if you can't comply with it, you could end up liable under it. Also, if you go to invest in and sell the company, the buyer or the investor will look at all those contracts and they'll think this company is really exposed here. It won't be able to do any of these things, or you know, if the other side breaches this contract, there's nothing they can do about it, or they're really dependent on one customer or one supplier. If they lose them, they're going to go into oblivion. So spread your risk, and you know, make sure that the contracts you sign protect you as much as possible. Also, although it's easy, you know, and it saves time and money to use template confidentiality agreements, template end user licenses and that sort of thing, beware of doing things like using the wrong template for the wrong scenario. So it's not much point in using a confidentiality agreement for a software license. And also remember, you know, that if you're using a template, you know, store that new contract as a separate job. Don't make all the changes on the template, send that to the other side, and then use that changed version as your next template, because it will be totally inappropriate. It's amazing how many people do that. Regarding lawyers, and this is one of the things we heard, you know, from Andy and Graham, is professional advisors cost money. And often it hurts people to use them because they're not actually getting something physical. And I know, because when I've used lawyers, is you're getting words in an email or over the phone, and you're not getting something tangible, and you're thinking, why am I paying all this money? And the reason you're paying all this money is because if you use us properly, you're going to save money and make more money. So knowing when to involve us is, you know, probably a case of how experienced you are. The more experienced you get, then later along the line you'd want to involve us. In negotiations with the other side, some people like the lawyers to negotiate on both sides. Some people like to negotiate with the other side themselves, and then go back and get the lawyer to make the changes, whatever works best for you. Give them clear instructions, you know, give an indication, get an indication of costs, and be clear on whether that's a fixed point or an estimate. And know that you know that you should build that amount of money into maybe what you're charging the other side, or what the amount of money you want to apply for when you're applying for a grant. Also beware of mission creep. You know, if you ask a builder to quote for putting a swimming pool in your garden, and then as time goes along you say, can I also have an extension and a garage and a wall, all those things are going to cost more. In the same way, if you say to a lawyer, can you do this and do this and do this, or you say to Andy, actually I've got these other claims I want to add on the patent application, or you say to Graham, actually I've got another brand I'd like to trademark, or I want to trademark in these countries, you know, these things are going to cost more. So you need to ask, if the job's going to get bigger, what it's going to cost. And as I said earlier, if it's all possible, any extra costs where you're involving lawyers, or you're having to get insurance, pass them along to the other side. If the other side is particularly difficult in contract negotiations, then it seems fair enough that means your legal bills go up. So it seems fair enough that you should, if possible, pass that on to what you charge in purchase price or license fee or whatever. Avoiding liability, how not to get into trouble. Not owning your IP is a fairly obvious one, and you might think that's easy, but a lot of times when a client comes to us and they say, can you find a patent application for us, and I start digging, I find they actually don't own what they think they do, because it's actually owned by another company who never transferred ownership. because that wasn't in the contract. Or there's been an error in the chain of title and it was meant to go from A to B to C to D, but it actually went from A to B and someone missed out C. As I said earlier, only sign up contracts that you can actually comply with. Beware of cash flow problems. That means, you know, if you are required to pay someone within 30 days, it's not much help if higher up the chain, you're only being paid after 180 days. So make sure that you've got back-to-back liability in that regard. As I said earlier, also be familiar with the regulatory framework you're operating in, because, you know, otherwise you can get in a lot of trouble. Are you infringing third-party rights? People like Andy and Graham, before applying for patents and trademarks for you, will do trademark searches to make sure that, that, you know, as far as they can see, there's nothing out there to stop you doing this. However, you've also got to be very careful. You know, as I said earlier, don't borrow content off the internet. If, for example, you decided to produce a virtual reality version of Piccadilly Circus and Times Square, and you've got a whole load of advertisements in your virtual Times Square or Piccadilly Circus, and a whole load of cars going along the roads or around the roundabout, have you got the rights to use the trademarks in those adverts? Have you got a right to use the trademarks and the branding for those designs? You know, I once met a guy and he was coming up with an AR app, and it was possible on this whereby you could photograph people on your photograph or film people on your iPhone and then put, you know, dress them up as Disney characters. So you could film a friend and then make sure they were dressed with Snow White. And I said to him, well, have you got a license to Disney to do any of this? And he looked at me blankly, and I pretty much ruined his day. Luckily, he hadn't gone public, you know, but it's amazing that, you know, look at what's out there, because, you know, these companies will sue you otherwise. A few other things you're going to come across as you grow is, you know, you'll be dealing with, you know, might be getting some research done in universities, and, you know, they are interested in publishing, but you might want what they're doing kept confidential until you file the patent. So you might, you know, you're going to have to make sure there that they will delay any publication until you've got your protection. Dealing with a small company is also, you know, different from dealing with a big company. If you are a startup, you can move very quickly, and you may need to meet investor guidelines, you know, timeframes to get investment or so forth. On the other hand, big companies often have a lot of things on their plate. They can't make a decision unless everyone is in the same room at the same time, and often they aren't. And you might have to become familiar with their SOPs as well. So it can be very difficult. I once had a client, it was a small software company. We sold them to a really big multinational, and I asked him a few months later how it was going, and he said, I can't bear it. He said, I'm often on these conference calls where we're making decisions, and no one ever decides anything. So I pass the time by scrolling down and seeing how many people are on the call. And I once got to 120. Now you can see how different the big business culture is from the small startup culture. Another thing is the big companies is they might be slow paying you, you know, and that may not necessarily be because they think, well, you know, what can this little company do about this? They have accounts departments dealing with a lot of transactions, and so they won't necessarily be able to pay you quickly, even if they're doing their best. And also remember that big organizations do not necessarily have endless amounts of money. You will be dealing with an individual team or department, and they have budgets too. Also, as I said earlier, you know, go to events and try and partnering meetups and try and identify a champion within one of these big companies. But you never know, because they might leave and you need a substitute lined up. Because sometimes you can find the person you're dealing with goes, or the company gets taken over and it changes direction, and they just drop you and they don't give a reason. But yeah, the reason is they're just not interested in what you're doing anymore. It's not the direction the company is going in, and it may have nothing to do with how good your technology or your offering is. Another thing is, you know, you'll be dealing maybe with businesses from different countries. Now, the differences in this regard are sort of changing a bit now, because people from all over the world end up working all over the world. And sometimes this is much to do with what the culture of the company is, or the personality of the individual. But, you know, at the same time, you can sometimes find that in Northern Europe, people are much more inclined to maybe stick to specific deadlines on things. And also, you know, be quite upfront about whether they're interested or not. America, on the other hand, I found often companies there can be really, really enthusiastic, and then sometimes it may not necessarily come to anything, but because the enthusiasm is sort of a way that they get to know people. If you're dealing in Japan or China or the Middle East, the relationship is very important, and it often means taking time to go out there when we're allowed to again, having a lot of visits, keep in touch over the phone, whereas with America or Europe, emails might be enough. Particularly in Japan, it can take a very, very long time to get to know companies and to negotiate the contracts before they feel they can trust you and move on. So be prepared for these things. Also, in a lot of countries, and China is a good example here, is it helps to have people on the ground there who are in that country and from that country, and they work for you. It's not enough to just have a customer or a manufacturing facility out there and just leave them to get on with it and not really be involved. So, you know, once you get involved in other countries, there is a lot of time and money and investment involved. As I said earlier, you know, get everything in good order, just as if you're about to sell your house. In the same way that, you know, you bought your house in good repair, you got planning permission, the extension, there's no ambiguity with the border, you have all the guarantees and the service schedule for your boiler. In the same way, you don't want your company to be in a mess. All your employees should have proper contracts, you shouldn't be behind on filings or paying your tax, you should only be using intellectual property you own or have licensed in. Beware of, you know, shareholdings where you have lots of little shareholdings in the company. Particularly that might happen at the beginning if you're crowdfunding. Those tend to put potential buyers off. Beware of clauses in contracts where there is a change of control clause, and that means that the other side can terminate the contract if someone else buys you, or they have the right to upon permission. That is a complete turn-off to buyers and investors, so avoid clauses like that in contracts if at all possible. Don't lie, because you're going to get found out and then you could get sued for breach of warranty. At the same time, you know, don't disclose every single minor breach. So every single time an employee by mistake sent an email to the wrong person, if you disclose all of those, you're either going to look really rubbish or you're going to look like you're trying to hide something serious with a whole load of minor stuff. And remember also, things always take longer than you thought. And that's the same with buying a house. So basically, decide how long you'd like to spend until you sell the company. It's probably going to take 3 times as much. We have had 2 cases. One was a company that was in a real mess. The contracts were in bad shape. They'd lost their software licenses. They needed to get permission from grantors of funding. there was some copyright they didn't own, and they were going to get sued for breach of copyright, and they, as a result, had to sort all this out, and the transaction took 11 months. I had another where we had been involved in all the patent work and done all the contracts, and therefore when the client came to me just before Christmas and said, I'm selling the company to a big pharmaceutical company, it's going to happen in 3 weeks, my 2 thoughts were not a chance, and my Christmas is ruined. In fact, it happened on time, and all it took, from my point of view, was a couple of phone calls where factual questions were asked, because they were in good shape, so there was nothing that needed sorting out. Now, if you're in the situation, the second case study, your life is much easier than if you're in the situation of the first case study. And the second case study, that firm got sold for a lot of money. They offered me shares, which I'm not allowed to do as a lawyer because that would be a conflict of interest, but it's really annoying because I'd probably be a millionaire by now. But that's the way it is. But you know, you really want to be in the bottom bullet point, not the bullet points one up from the bottom. So we're probably getting to the end now. I don't know if we've got any questions. But if we haven't, then our seems like it hasn't, but we've overrun a bit. So if you have any questions, then email us. Our email is at the back of the slides, and also we'll be sticking these slides online anyway. So hope you enjoyed it, and hope to hear from you soon.